Good morning everyone, my name is Michelle. I hope you're doing well. Welcome to another video. It is Sunday morning and I'm going to get straight into this one. I've got a couple of interesting things to talk to you about. I went down a little bit of a rabbit hole when I saw this published in the Independent newspaper. New explanation emerges about mystery 911 call alerting police to Idaho student murders. The 911 call alerting law enforcement to the murders of the 4 University of Idaho students has been long shrouded in mystery after Moscow police said the caller initially reported an unconscious individual in the home, and that has confused a lot of people. It confused me. Why did the 911 call report an unconscious person when it was clear to anybody who saw any of the bodies of Ethan, Xana, Kaylee or Maddie, whichever was seen first by the roommates or any of the friends that they called to the house on that fateful Sunday morning? And we know that the call was made from the cell phone of one of the 2 surviving roommates at 11:58 a.m. on Sunday, 13th of November. And the dispatcher spoke to multiple people. Now, we've heard that it was one of the surviving roommates who collapsed outside. She came in outside, tried to call 911 and collapsed. So it was her that was the unconscious person, not any of the murdered victims. You know, officers arrived at the home to find a bloody scene, and it's been speculated whether the surviving roommates actually saw any of the bodies or whether they did, and there's something very strange going on if they say that they were unconscious rather than dead. It was bloody. We know that there was lots of blood spatter at the scene. So questions have persisted around why the caller reported an unconscious individual. Was it one of the surviving roommates? Did the dispatcher not understand what they were trying to say? And an unconscious person was one of the surviving roommates. Well, this is interesting. The potential reason for the 911 call has been speculated in Airmail's article, The Eyes of a Killer. So I went to that article and it's a blog post. It's long. I'll leave a link to it in the description box. All the town's 911 calls, this is the town of Moscow, are routinely routed to Pullman, about 10 miles away in Washington State, and home to Washington State University, and we know now the home of Brian Christopher Kohberger, the alleged and accused killer of the Idaho 4. Where they're handled by the civilian employees of a municipal agency called Whitcom 911. The calls come in from the local Whitman and Assotin counties, as well as the city of Moscow, 2 universities with a total of 42,000 students and 70 additional agencies, and they are severely understaffed. The overtime schedule often adds up to a grueling 20 hours a week. In fact, the Dispatchers Guild has complained about the ability to uphold public safety. So, therefore, when the callers are agitated, rather than risk injury delays by probing for details, the responders swiftly assign a generic explanation, unconscious person, and that's one of the standard catchphrases. It can mean precisely that somebody is unconscious, or it can be shorthand for something more ominous. So is it true that the dispatcher just couldn't understand what was going on? You know, one of the surviving roommates tried to call, passed it on to a friend. The friend didn't know what on earth was going on. It was just chaos. It seems plausible. It does. So I looked up Whitcom 911. Here they are. Provides police, fire and EMS dispatch services for all first responder agencies in Whitman County, Assotin County and the city of Moscow. Our multi-agency 911 dispatchers operate radio dispatch equipment, multifunction telephones, recording equipment, computer-aided dispatch, JAS mapping program and alarm monitoring software to provide public safety services for community members and agency partners. So, become a dispatcher. It offers on-the-job training. No formal training is required before applying. So yeah, it seems plausible, honestly. that it could simply have been that the dispatcher was confused. And it could be as simple as that. Let me know what you think. I think that's plausible. All right, I want to move on now to the court documents. So this is State of Idaho versus Brian C. Kohberger. And all the information about the case is put into this section right here. So the latest piece to come out, we've already talked about in a video, the tightening up of the gag order. We've got notice of the criminal hearing, so dates for your diary here. It's expected that the preliminary hearing in June will last for 5 days. Starts at 9 a.m. But I thought this was interesting. So this was filed on the 12th. Ann Taylor, public defender, appears on behalf of Brian C. Kohberger, the above-named defendant, and the above title matter, and requests that a preliminary hearing be scheduled in accordance with the time limits set forth in Idaho Criminal Code 5.1. Counsel hereby moves for reduction of the bail set in this matter. And what was the bail set in this matter? Do we remember? The bail set was no bail. Next court date, 6/26/23 at 9 a.m. They look like 4s. It looks like 4/24, but they're not. It's 6/26, because that's the date of the preliminary hearing. These are the minutes of the last hearing. So, court set, preliminary hearing, June 26th. We've seen the schedule for that. Alright, so no bail. So, we want a reduction of the bail set in this matter on the grounds that it is excessive. And further, notice is hereby given that counsel will present argument in support of the motion to reduce bond at the time of the preliminary hearing status conference, and or preliminary hearing scheduled in this matter if the defendant is in custody. These are just standard lines, right? We know the defendant's in custody. Counsel intends to present evidence and or argument in support of all applicable factors outlined in Idaho Criminal Rule 46. Counsel further notifies counsel and the court that such requests will be heard at the preliminary hearing status conference unless the case proceeds to hearing. Well, we know it's proceeding to hearing. If the case proceeds to hearing, bond shall be addressed at the time of the preliminary hearing. Counsel hereby moves the court for an order shortening time for bond to be addressed if timing is insufficient. The defendant hereby demands a speedy jury trial as guaranteed to him by the 6th and 14th Amendments of the United States Constitution, Article 1, Sections 7, 13 and 18 of the Idaho Constitution. So he wants a speedy jury trial. Well, why wait 6 months for a preliminary hearing? Why not have a swift preliminary hearing and then you can proceed to a speedy jury trial? But then, filed on the same day, the court advised the defendant of the rights he is waiving. Upon waiving his right to have a speedy preliminary hearing, defendant understood. In response to inquiry from the court, the defendant stated he did not need any additional time to speak with Miss Taylor regarding his waiver. Defendant waived his right to have a speedy preliminary hearing. Miss Taylor agreed with the waiver. Court found the defendant's waiver of speedy preliminary hearing was knowingly, intelligently and voluntarily given in open court with the assistance of counsel. Court accepted the defendant's waiver. Preliminary hearing, June 26, 2023. So, whatever was filed on the 12th of January requesting a bond reduction and requesting a speedy trial, they might try again to get his bond reduced from no bond to massive bond in June. But nothing's going to happen until then. Nothing. So those are all the court documentations we've got so far. So, yeah, he's sitting there till June. That's it. That's it. And with the evidence mounting against him, he's likely to be sitting there for the rest of his life. Let me know what you think about all of this in the comments below. I've been Michelle. Hope you're well. I'll see you in the next video. It's goodbye from Miss Tillington and Miss Cassie Springer. Bye, guys.